Good evening, comrades. Thank you for joining us for another session of Why Marx. Tonight, we're looking at the question of Marx and law, and by extension, the state as well. We're very pleased to have with us Mike Macnair, recently retired law tutor at the College on Oxford, and he is precisely looking at the holes in Marx and Engels on the question of law and the state. And then in the Q&A, we'll be discussing more about the law in a future society, in the dictatorship of the proletariat, etc. That's more for the question and answer session afterwards. Mike's going to speak for about 30 to 40 minutes. If you've read his article, it's a bit theoretic, but it's very interesting and does deal with some of the stuff that comes from Hegel and the concepts that Marx and Engels took from Hegel's and the problems therewith. Without further ado, Mike, over to you.
Okay, thank you, Tina, and thank you for the invitation to do this. I should apologize, I guess, to comrades for giving you this bit of a bastard of an article from Critique as pre-reading. The background for this is that the amount of literature on Marx and Engels and law is absolutely enormous. It's so voluminous that it's possible to have a whole option studies for a term on Marxism and law for for undergraduate or postgraduate students. So there's masses of this bloody stuff, and characteristically, actually, the very little of the stuff which is written actually directly engages with the rest of the stuff. So that I gave you this article because in the second half of it, it does attempt to engage to some extent with what the subsequent authors writing about Marx/Marxism and law have written. But at the same time, what I'm going to talk about today is perhaps at a bit more of a superficial level and to be a bit more about Marx rather than about subsequent appropriations of Marx. I'm not going to say Marx versus Engels because I don't believe in this story. Marx and Engels functioned as a team. Marx wrote part, at least, of the Anti-Düring, which is the scandalous text, which is regarded as being the place where Engels vulgarized Marx, and indeed read the whole text before any part of it went into the Volksstaat, where it was published in serial. So that the idea that there's the Engels vulgarized Marx story is originally Bernsteinian revisionist story. Ben Lewis has drawn our attention to that, and it's then picked up by leftists by way of the sections of the left having picked up on the Bernsteinian critique. Anyhow, going back to this, I'm going to put a PowerPoint up. This is a quotation, an extended quotation from a letter of Marx to Friedrich Walter in New York in 1871, and the bulk of the letter is about the conflicts of the quote Marxist unquote wing of the First International with the Lassalleans and with the Bakuninists. And then at the end of the letter, we have this note as to political movement. And Marx says the political movement of the working class has as its object, of course, the conquest of political power for the working class. And for this, it's naturally necessary that a previous organization of the working class itself arising from their economic struggles should have been developed up to a certain point. On the other hand, however, every movement in which the working class comes out as a class against the ruling classes and attempts to force them by pressure from without is a political movement. For instance, the attempt in a particular factory or even a particular industry to force a shorter working day out of the capitalists by strikes, etc., is a purely economic movement. On the other hand, the movement to force an 8-hour day, etc., law is a political movement. And in this way, out of the separate economic movements of the workers, there grows up everywhere a political movement, that is to say, a movement of the class with the object of achieving its interests in a general form, in a form possessing a general social force of compulsion. And it's this form expressing a general social force of compulsion, which is the sorry, I'm not handling my.
You can do it with the little arrows on your keyboard. You can go back and forth.
Okay. Yeah. Here, the point is that it's the working class trying to achieve laws in its own interests, trying to give its interests a general social force of compulsion, which is the method which prepares the working class to actually fight for political power. It's the first step on the road to a struggle for political power, as opposed to leaping directly from the purely economic struggle, the strike struggle, which of course goes back a hell of a long way. Strike struggles, the Confederacies of Masons Act 1425 is a piece of legislation which penalizes building workers forming associations to try and force raising of wages. The Crown against the Journeyman Tailors of Cambridge is a prosecution in 1721 in which journeyman tailors are prosecuted on the basis that conspiring to raise wages is a crime at common law. And by the 1730s, we have precedents of indictments for conspiring to refuse to work more than 16 hours a day, to the great loss and damage of their employers. So this sort of economic struggle is endemic in the history of capitalism, and what's not endemic in the history of capitalism, but begins with Chartism, is the struggle for the general interests of the working class, taking the form of taking a general social force of compulsion, taking the form of laws. And Marx refers essentially to the 10-hour day campaign here. So law, therefore, is actually pretty fundamental to Marx's project of class politics. But the question is, there's a counter argument, and this is the argument that the law is inherently subordinated to the economic base. And so we have, this is a very celebrated quotation from the preface to the critique of the contribution to the critique of political economy in 1859. Marx comments that he studied jurisprudence, that means he studied law. He pursued it as a subject subordinated to philosophy and history. But when he started looking back at the Hegelian theory of law in the 1840s, he reached the conclusion that it's not a matter of the general development of the human mind, but the material conditions of life. And so we get later on, that I've highlighted, at a certain stage of development, the material productive forces of society come into conflict with the existing relations of production, or this merely expresses the same thing in legal terms with the property relations within the framework of which they have operated hitherto. And later on, next paragraph, in studying such transformations, it's always necessary to distinguish between the material transformation of the economic conditions of production, which can be determined with the precision of natural science, and the legal, political, religious, artistic, or philosophic, in short, ideological forms in which men become conscious of this conflict and fight it out. So this is one of the famous proof texts for the idea that the economy is the base, and the political ideologies, including law, among other things, are the superstructure. We've got not quite the same statement in the Critique of the Gotha Programme. We have a translation problem here. Law, Marx says, can never be higher than the economic structure of society and its cultural development conditioned thereby, and only then later on, when productive development, only then can the narrow horizon of bourgeois right, meaning bourgeois law, be crossed in its entirety and society inscribe on its banners, from each according to his ability to each according to his needs. So this is the Critique of the Gotha Programme in 1875. We have to be conscious of the fact that this is rough notes stolen by Marx from work which he was made in time, stolen by Marx from work of a quite different character which he was engaged in, and that it was not intended for publication but to be passed on to the draftspeople of the Gotha Programme draft. And indeed, lastly, has made the point in his recent platypus review of a new edition of the Critique of the Gotha Programme that the actual programme as adopted radically reduced the concessions, the Lassalleans, which were made. I've got the German here simply because of this issue about translation. The German word Recht can mean my rights, as we talk about human rights, or I have a right to my house, or stuff like that. But it can also mean law in general, as in the legal system. And so one could talk about Deutsches Recht. A statute, an act of parliament, is a gazettes. The same issue arises, in fact, in all the European languages. In French, it's droit. D-R-O-I-T is a right, but also droit français, the French legal system, and a loi. I can't remember the loi. They're usually called by the name of the proposer, but a loi is a statute. In Italian, diritto is a right, or alternatively, the legal system, legge is a statute, and so on. How do we do in English? However, we use the word law to mean the legal system, English law, but also to mean the dangerous driving law, the relevant section of the Road Traffic Act, or the theft law, meaning the Theft Act. But we never use the word law to mean a right. So there's an endless translation problem. And the particular translation problem, back to, Hegel, Hegel's book on the philosophy of law is translated as the philosophy of right. And that has a contamination consequence, which is that lots of people translate Marx when he's writing about law as being writing about right. Anyhow, there it is. But right, law can never be higher than the economic structure of society and its cultural development conditioned thereby. I have to say, I am not myself particularly enthusiastic for this formula. I said this is Marx's rough notes on the draft of the Gotha Programme. The problem is that the economic structure of society mutates, and in that process of mutation, the law may in fact move rapidly ahead of the development of the society, as well as law. lagging behind the development of the society and moving rapidly ahead. The clearest instance of this is where you have law imported into new legal ideas imported into a country as part of a modernization process, where the law then is taken from a country which is further developed, and the law is in contradiction with the social order in that particular way. The converse is, of course, as I said, that the law can be extraordinarily aged and anachronistic. There are statutes in force in the UK, legislation passed in 1217 and 1267. It remains the case that the theoretical position of law in England is a legal position in England is that the land is all owned by the king, but everybody else has a fee simple, a feudal tenure under the king. Now, there's no practical difference between the fee simple on the one hand and the ownership which is available in Scotland, because as soon as they got their own parliament, the Scots abolished feudalism, the English having not yet got around to doing that. But my point is simply that the law can never be higher than the economic structure of society, and its cultural development continued thereby is a problematic statement. I also think that the general conception of the first stage of socialism and second stage of socialism in the critique of the Gotha program is problematic. So we've got this second side. We've got the side one of Marx, which is about the connection between the law fighting for legal rights, fighting for legal coercion, for measures which have a compulsory effect on the society as a whole. And we got, on the other hand, the argument of Marx for the fundamental driving force being the economic practices, and the economic practices as the base, and the legal juridical argument as the superstructure, which is, and there is endless controversy about this particular thing, and I'm not going to go at the moment for this one further into it. A step further, where does Marx's theorizing about law come from? We start actually with an article by Donald R. Kelly called The Metaphysics of Law, an essay on the very young Marx, from 1978 from the American Historical Review. And the point that Kelly makes in this article, The Metaphysics of Law, is that Marx started his life as a law student. Not started his life, but started his adult life as a law student. And he was taught for private law by Savigny, and for public and criminal law by Gans. And Savigny and Gans were violent ideological opponents. Savigny, who is actually the older of the two, but also very much longer lived of the two, is famous for his work on Roman law and the history of Roman law in the Middle Ages and a whole load of stuff of this sort. But he also wrote a polemical pamphlet on the vocation of our age for legislation and jurisprudence, written in 1814 and translated into English in 1831. Savigny is arguing for laws as having a national character, and therefore against any sort of idea of universal rights, universal common features of law, and in particular against the export of the French Code Civil, which had been adopted when in the Rhineland, when the Rhineland was under French occupation as part of France, in fact, but then was retained in the Rhineland, while Prussia had its own separate code, and the non-Rhineland states, Austria had its own separate code, and the non-Rhineland states had what was called jus commune and jus proprium. That is to say, they had the law which was taught in the universities, which was Roman law as it was interpreted in the Middle Ages and early modern period. And then they had particular statutes of Württemberg or Bavaria or etc., etc., etc. Each of the, or Hamburg, each of the different states had its own. So Savigny is defending this setup against the idea that, given that the French code was so efficient, everybody should adopt the French code. Gans is a critic of Savigny's, but he's chiefly famous for having edited Hegel's book, 1820 book on the philosophy of law, natural law, and political science. And the standard translations of Hegel's philosophy of right are of Gans's editions, and actually Gans's edition had actually contained quite a lot of Gans as well as stuff of Hegel. So Gans is the Hegelian theory of law, and it's not straightforwardly general natural law theory of the sort which advocated for the Code Civil, but it's a theory according to which there is a developmental logic in the history of law, and that developmental logic in the history of law leads towards liberalism. And that's what makes Gans hostile to Savigny, who is a German nationalist of a conservative type. And why is it translated into English in 1831? The answer is this was the conservatives in the English bar using Savigny to polemicize against the idea of modernization of English law by codification. So here's Marx in his youth, and he starts, therefore, in this context, Marx is on the Gans side of the barricades. He's a he's a Hegelian legal theorist. Unambiguously a Hegel legal theorist, but then he partially breaks with Hegel, and the way in which he partially breaks with Hegel is to have this idea that the historical development is driven by the development of the productive relations, means of production and relations of production, by the political economy, and not by abstract general human emancipation and logic towards liberalism and all of that stuff. But then the question which is posed, and I pose this question because it's there in the debate between Savigny and the French liberals and the Hegelians. What is law? This slide is a quotation from a law report of a case in 1345 in England. Thorpe is trying to persuade the judges that they ought to do what they did in a previous case and not go off at a different thing. He says, I think you will do as others have done in the same case, or else we will not know what the law is. Mr. Justice Hilary, it, meaning the law, is the will of the judges. Chief Justice Stoner, no, law is reason. So Thorpe is what modern legal theorists call a legal positivist. He thinks that we can find out what the law is by looking at the authoritative sources, in this case, previous cases, but it could equally be statutes passed by Parliament. Mr. Justice Hillary thinks the legal system is just a system in which we trust judges. This is, I've tagged it as law's ideology theory, that because that's closer to what modern theorists of this sort think. Chief Justice Stoner is a natural law theorist. He thinks that law arises out of natural reason, whatever the hell that means. So that this is not, this problem about what do we mean by law is a non-new problem. As I said, the background to both Savigny and Hegel is that they're responding to or critiquing in different ways the, quote, school of natural law. And the school of natural law, we start with, it's not it's quite as simple as this, but the famous list, Hugo Grotius, 1583-1645, is the author of a book on the laws of war and peace, which grounds international law and international relations on natural law, natural reason theory. John Locke, famous in terms of British political history, he wrote polemics in favor of freedom of conscience and in favor of the right to overthrow the king if the king acted tyrannically. He had to run away to the Netherlands in 1683 and came back with King Billy on the warships in 1688. Christian Thomasius, I put in the same camp. He's a German legal scholar of the later 17th century who had a sufficiently uncomfortable relationship with the powers that be that he had to move around from place to place and was denounced as a heretic. Then my second tranche, Samuel Pufendorf, who is actually more contemporary with Locke, earlier and older than Thomasius, is again a natural law theorist, again a Protestant natural law theorist, but he's a much more accommodates himself to the existing political order, and his book is extraordinarily widely read because it can be read in that way of natural law justifies the order of things as they are. Jean-Jacques Burlamaqui and Christian Wolff are both writers in the same school, closer to Pufendorf's approach than they are, at least, to the politics of Locke and Thomasius. So what's happened essentially is that natural law in Grotius and Locke and Thomasius is revolutionary politics. It's a revolutionary politics of the capital, of the bourgeoisie, of the capitalist class, which is justifying the right, the natural law arguments are justifying the right to overthrow the existing state order. That's most clear and explicit in Locke. But it is actually also there in Grotius, because a significant part of what he's doing is justifying the self-defense of the Dutch state against the Spanish from whom they'd revolted. But Pufendorf, Burlamaqui, and Wolff represent a movement of natural law into accommodation to the existing order, and the idea that natural rights mean that you shouldn't expropriate the landlord class because they have natural property rights which have to be protected. And it's in response to this second layer of natural law as a conservative theorization, which we've got come back to us in the form of human rights as just the human rights of corporations, or for that matter, actually, we've got a restoration of Catholic natural law, medieval Catholic natural law theory in the form of the overruling of Roe and Wade, and associated events. So natural law has this characteristic that it can be revolutionary, but it can also be violently conservative. There's an alternative which Marx actually doesn't directly address, and he doesn't directly address it because it's not part of the debates on the theory of law which he learned when he was a student in Berlin. And this is legal positivism. And the basic idea of legal positivism is that natural reason is irrelevant. Law is the rules which are laid down by some sort of political authority. And on my list of people, I've started with Jean Bodin, but Thomas Hobbes, I started with Jean Bodin chiefly because he's cited by Dan Lazare in our controversies about constitutionalism in The Weekly Worker. But Thomas Hobbes is immediately influenced by Jean Bodin, and Hobbes is still taught to students, law students, and I guess philosophy students have to learn Hobbes and read Hobbes. I've contrasted Robert Wiseman, who, because Hobbes, of course, was a advocate of the unlimited political power of the sovereign, the legislator, the person who lays down the rules, is above the law. And Wiseman, in contrast, tries to say, yes, there has to be sovereignty in a legal system. Somebody has to lay down the rules, but it doesn't have to be a one-man government. Surprise, surprise, Wiseman is writing under the Commonwealth in 1657, before the return of the monarchy. David Hume didn't exactly write about law as such, but he argued that it was impossible to have a rational judgment. You can't reason from human nature to, or other such arguments, to what ought to be the case. So there's no objective morality. If there's no objective morality, then it also follows that there can't be any natural law. And Hume's argument of this sort is cached not in his philosophical works, but in his history of England in the 17th century, which is basically royalist and argues that the belief of the rebels of one sort and another that there was such a thing as natural law, which could override the monarch's orders, led to disorder and catastrophe and so on. Jeremy Bentham is still very much taught, and so is John Austin. Marx commented on Bentham, but not in a way which comments on Bentham on law. It's a lovely passage. That arch Philistine, Jeremy Bentham, that insipid, leather-tongued oracle of the ordinary bourgeois intelligence of the 19th century. Bentham is among philosophers what Martin Tupper is among poets. Both could only have been manufactured in England. Martin Tupper, you can Google him and you'll find that he's a sententious moralist writer of not very good poetry. John Austin was a pupil of Bentham's. Let's see, back to here. And at the same time, there's what's called the exegetical school in France, which again argued that there was no such thing as natural law. And one could find out what the will of the legislator was by the ordinary natural meaning of words. Okay. this stuff goes back, and again, this is not a new discussion. And going back substantially further, Gaius institutes, we've got natural reason. That which natural reason establishes between all men is maintained by all communities. But then, on the other hand, the basis of positive law is the agreement of the people to it. And the jurist Julian, who is actually a little earlier than Gaius, says statutes themselves bind us for no other cause than that they've been accepted by the judgment of the people. It's appropriate that what the people has approved without any writing should bind everyone. So we've got a conception of law here which has natural law in it. I want to be very cautious about what they're doing with natural law. Aristotle, who had this conception of natural law, argued that slavery was by natural law because some people, for example, North Europeans, did not get enough sunlight, so the brain didn't develop properly, and it was necessary that somebody should give them orders, so that North Europeans were natural slaves, which is a nice inversion of the usual form of racism, but at the same time, it's within that general framework. On the other hand, other aspects of it, so for example, I say that my if you take my wine and make it into vinegar by consciously making it into vinegar, I can't claim my wine back because it's no longer wine. That's an observation, or that if a river moves, the boundary of the land defined by the river moves, etc. These are observations about the world which are being used as natural reason to affect reality. So we've got this natural reason stuff on the one hand, but on the other hand, consent. With Christianity, we get something very different. This is the Emperor Constantine who converted to Christianity. It's necessary and permitted that we, the emperor alone, shall investigate an interpretation that's been interposed between equity and law. Or Justinian, a couple of centuries later, whatever is written in the text which he issued may be seen to be ours, in spite of the fact that it's actually got names of all the various authors who wrote it. It's a collection of extracts from various authors. And if anything appears doubtful, the emperor shall give correct guidance, as he has the sole right to do under the laws. So the concept here is expressed much later by Peter Lombard. I've just chosen that quote because it's clearer than the earlier quotes. It's the story of Adam and Eve and God says, you may not eat the fruit of the tree, knowledge of the tree of good and evil. And Eve eats it and persuades Adam to eat it, and they're cast out of the Garden of Eden because they're sin. And the theory is there's nothing wrong in principle. There's nothing immoral about knowing what good and evil is, but it's simply because God prohibited them. And so law then in this theory is only the commands of a determinate superior, as it is in Hobbes, Bentham, and Austin. So where we come to actually is I've been pursuing a line of argument about the question what law is, which was the line of argument which was being debated between Savigny on the conservative side and Gans on the liberal side, and which was being debated between natural law writers in the 18th century on the one hand, and the positivists emerging, positivist legal theory emerging in England in particular, but also in France on the other. The theory is a question of the concept at the end of the day. This is a question of the concept of authority. The question of what law is turns out to be a question of political authority rather than of as much as it is of the theory of what the hell law is. And indeed, back to slide 2. Political movement with the object of achieving its interests in a general form, in a form possessing a general social force of compulsion. That at the end of the day, what Marx is engaged in the debates about what law is about the question of what political authority is, and who at the end of the day gets to say, is this the government? Is it the judiciary? Is it the public? Is it the working class as a class? The underlying issue in these debates about legal theory in which Marx was engaged are debates at the end of the day about the nature of political authority. And I'm going to leave it at that.
Thank you very much, Comrade. A tour de force of legal history and stuff. That was very interesting. Comrades, if you want to ask a question or make a comment, please click raise hand. And I'm going to ask you a couple of questions first, if that's okay. I mean, in your article, you outlined that there were various holes of Marx and Engels on the theory of the state, which you didn't talk so much about tonight. But I wonder where you see, because Engels wrote about this in Origins of the Family and Private Property, etc. And he seemed to locate the rise of law or the development of law and states in the emergence of class society and the end of, toward primitive communism, etc. And you get into a period of the development of class society. Is that where you locate where laws and the state come from? Is it class society that basically, or were there situations before, in communities and societies before class society where laws were necessary to organize?
Okay, dispute settlements. Disputes and dispute settlement exist in the most primitive societies. And the specialization of some people in being good at settling disputes, shaman and on the one hand and chiefs on the other hand, may have dispute settlement roles. People may be mediators or they may be judges, people who have political power, quote, big men, unquote. I know, I'm sorry, the sexism of it, but it's the sexism of the societies in transition to, because what we're talking about is societies in transition to class society. My understanding, for what it's worth, is that law, to be law, needs to be something other than customary dispute settlement. And we can see this, there's two levels of it, one of which is a point made by Jim Harris back in 1980. We have a socially obligatory customs in this country as well as laws. You don't commit an offence if you fail to buy your round. There's no legal obligation. You can't be forced to buy your round by any sort of legal proceeding or anything like that. Equally, it's a socially obligatory custom. I don't know if it still is, but it used to be when I was a kid, a socially obligatory custom to pass the joint. That's an offence. It's a supply offence under the Misuse of Drugs Act. So that we need to be able to distinguish between laws on the one hand and customs on the other. And we get we get laws, it seems to me, when we have not merely a regime of private property, but also class society, but it's not always invented. So ancient Egypt doesn't seem to have had laws. Very ancient China doesn't seem to have had laws. Laws are introduced in the period of the Qin dynasty and the Han dynasty, and the Confucians complain about them as being an importation from the barbarian West, because the the concept is invented in Mesopotamia, as far as it's possible to see. We have people writing laws and legal statutes, inscribed statutes and stuff like that in standard form contracts and things of that sort in Babylon and places like that. Marx, of course, at the time when he wrote his very early stuff, he wasn't aware of this because none of it had been translated. The discovery of how to read cuneiform was contemporaneous with Marx. Okay, so the issue is there's a separate question about the state. Because the state, seems to me that there's certainly the state in ancient Egypt, but no law. There's the state in very ancient China, but no law. Sharia, Islamic law, is law, but it's not state law, except in Ottoman Turkey. The Sharia is the law which is practiced by the ulama, the Islamic legal specialists. The state, the sultans and various other state bodies of one sort and another are non-legal. And so the law and the state are two separate things. And it's, I think, the influence of Hegel which results in Marx and Engels conflating law and the state, and in consequence the state as a producer of infrastructure, which is true of the ancient Egyptian state, but equally of the Roman state and the Greek state and this Greek city-state and so on and so forth. The state as a redistributor, the state is associated with redistribution to avoid social conflict, again, all the way back to ancient Greece and Rome. The state as a war maker. And these aspects, the absence, the fact that the state is conceived of purely in terms of the internal relations, has the effect that it's connected with the fact that Marx is never able to finish Capital, because in order to finish Capital, he needs the role of the state in the economy. And he hasn't got.
Thank you. Have you broken up? No, sorry.
It broke up for a bit and then came back. I think it's unstable. Is that helpful?
Yeah. Well, I mean, what about sort of, the need to enforce laws? The state has a function surely to enforce laws.
Okay, medieval Iceland has a really elaborate and complex law code. Yeah. So it seems true actually of the Brehon laws in Ireland and the Welsh laws before the English conquest. Really complicated, professional lawyers. Seriously, how's that enforced? There's no state. The answer is it's enforced by the collective action of the whatever one wants to call it, the respectable citizenry. In Iceland, actually, largely by vendetta, the laws are enforced because the sanction which lies behind them is you kill my son, I kill 2 of your sons, you then respond by killing 3 of my daughters, and so on.
It's out of hand quickly, yes. I can see that. In terms of, I mean, you did mention, you spoke briefly about the base superstructure, which is, that's kind of what Marxist ABC, what you learn.
Yeah.
You critique that, but I do want, I mean, you have a quote of Engels in your article, in your longer article, where he describes justice, as a glorified expression of the existing economic relations. And you could go further and saying, if you look at the base superstructure, but also to keep the base alive, you have that idea that laws merely exist to support the rich and keep the existing status quo. But you have some critique of that. You didn't go much into that, but what's your basic problem with that idea?
I think it's basically correct. It's just that it's not loose jointed enough. Yeah, so Western Europe and Japan have feudalism. And having feudalism means that certain legal categories can develop, but they don't have to develop. So the legal categories are made possible. You can't think jurisdiction as a private right without the development of feudalism. The idea that that taxes is a private right of the crown, which you can just hand out and say, okay, blogs, you can collect taxes from your peasants. That's a feudal conception. And in the same way, the modern corporation, we need to have capitalism in order to have the modern but it's not the same thing as having corporations as such, but in order to have the modern business corporation with all its particular features, we need to have capitalism, but at the same time you can have capitalism before the emergence of the modern corporation. So it's the Romans had difficulty in thinking the concept of commercial agency, basically because they used slaves to make contracts on behalf of their owners, and sons because the son is absolutely is not owned by his father, but is in patria potestas, and everything that the son owns belongs to his father or grandfather, as the case may be. And then the consequence is we can use slaves or sons to go overseas and make contracts on our behalf. We don't need the concept of commercial agency, and therefore we don't develop the concept of commercial agency. So in that sense, the point is that the underlying economic practices are fundamental, and the conceptual stuff is secondary. Give a second concept against Foucault. Foucault argues that the Enlightenment, and indeed Adorno and Horkheimer argue that the Enlightenment give rise to the prison and the lunatic asylum as forms of resulting from the Enlightenment conceptions of order, in essence. So the Enlightenment has its dark side, and the Foucaultian argument is that is much more elaborate, more of the same sort of idea, that it's a polemic against Marxism on the basis that it's the ideas, the political cultural ideas, which are determinative and not the social practices. But as soon as you start looking at Foucault's sources for the origin of the lunatic asylum and the prison and so on and so forth, it turns out that why he makes it appear to arise out of the Enlightenment is because he's only looking at France and Germany. He's not looking at the Netherlands or England or Northern Italy, which is where these things emerged in practice before they were theorized. They were started up as pragmatic methods of disciplining the lower orders without there being an attachment to the sort of anything remotely like the sort of Enlightenment theorizations which Foucault blames for the prison, the lunatic asylum, sexuality, and so on and so forth. So on that side, yes, I think Marx is right. What I'm just saying is that I think that the formulations which are in the preface to the contribution to the critique of political economy and in critique of the Gotha program make too tight a linkage. There's a real linkage. Things set limits. The productive forces set limits to what's possible. The relations of production set limits to what's possible. In a sense, we can see that the Soviet Union is a sort of spectacular example of this, because it's the insufficient, underpopulated country with low development of the forces of production, with agriculture a standard level comparable to the European 11th century rather than to the West European 15th century. And then you try to leap over capitalism. What you get is, in fact, the reinsertment of both the working class and the peasantry through the collective farm, the working class through the system of factory passports and the attachment of welfare rights to your particular employer, so that we actually get feudalism. Stalinism is, in that sense, it's not entirely, but in a certain sense, it's a form of feudalism. So in that sense, yes. But on the other hand, as I say, we can't, because it can be the case that we change the law radically, and by changing the law radically, we change the society radically. Henry VIII dissolved the monasteries. So he shut down most of the institutions of education and charity operations, but also actually quite a lot of them were just opportunities for monks to have fun, and hands out all the land to the cronies and to people who paid up front substantial. They didn't. It wasn't cheap. They got a lot of money out of it, but nonetheless, the effect of that is to sharply shift forward marketization, and that's it's an intervention in the same way as I said the Kemal Ataturk in Turkey. Fought a war and won, and then legislates to adopt the Swiss code as the civil code of Turkey, and then going along with that, there's legislation prohibiting beards and stuff like that, prohibiting the veil. Which is designed to forcibly secularize and modernize Turkey. And it did really quite significantly secularize and modernize Turkey. Turkey did not get colonized by the West in the way in which Syria and Egypt did. So it's a sort of, is that helpful?
Yeah. I mean, that does touch on the last question I want to raise with you is how can socialists view laws, or how do we engage with law or see law in a future society? I say, the dictatorship during the period of the dictatorship of the proletariat, would we use bourgeois laws or courts? Would we use our own laws? Would it be a period of lawlessness? Do we just smash the state? Is the old smashing the state or the withering away of the state, or one after the other? Is there, how do socialists engage with laws?
I share the view, which I think is in Engels, that law at the end of the day, both the state and law, which are separate entities, will at the end of the day wither away. And the form of the withering away is the supersession of occupational specialization, what's unhelpfully called, quote, the division of labor. Occupational specialization is the expectation that I will be a law lecturer for the whole of my life. I haven't actually been a law lecturer for the whole of my life. I fitted Speedos into cars on the Cowley assembly line back in my youth, and spent a year chasing debtors and fending off creditors for the left press, and another 9 months working in a tin can factory. So, but the idea that basically we will become specialists, and similarly that politicians will be specialist politicians and judges will be specialist judges. In order for law to wither away, that occupational specialization needs to wither away. it needs to. We need to. We need to return the public power to the public. Now, there are transitional methods which we can adopt in relation to this. So, the defense and restoration of trial by jury. Codification, in fact, surprising as it may seem, codifying the law has the advantage of reducing the autonomous power of the, it doesn't eliminate it, because you can't eliminate it, but it reduces the autonomous political power of the judges and the lawyers as such, because the code is there, a text which we can appeal to in the same way as people appeal to the Constitution of the United States. It isn't necessarily the case that that what the judges say is the last word about what the Constitution is, whereas with the English system of uncodified law and uncodified constitution, it's very difficult to overcome the idea that the judges have the last word as to what the law is. Yeah. Okay, so that's a step. These are steps in the direction. Similarly, short service conscript police force as opposed to long service volunteer police force, short service conscript army as opposed to long service volunteer army. The effect is that many more people learn the capabilities that are needed in order to do the job, and we're undermining the social specialization of function. So that's step one. Step two, the other side of it. Are we going to leap with one bound? We're free and we're in the kingdom of freedom. I think the answer is clearly no. There are approximately 5 million small businesses in the UK. A significant number of these are sham small businesses which are just set up. The reality is you appear to be a small business, but you're in fact working for a single employer. Or you appear to be a small business, but the reality is you're actually on the dole, but the government likes to pretend that it's supporting small businesses when in reality what it's doing is paying people the dole. But nonetheless, you're still talking about a fifth, something like that, of the working age population are in business for themselves. Farms, interestingly, we don't think of farmers as peasants, and I think we rightly don't think of farmers as peasants because the level of capitalization, this is now probably of all industries one of the ones with the highest organic composition of capital. Is because of the level of tech and the value of the land and so on and so forth. But nonetheless, the number of people employed in the farming sector has radically diminished, and to a considerable extent, its families. And we've now got, as a result of the reduction in taxes, in inheritance taxes and a whole load of stuff of that. One's not enough, but there's a big shift. There's a lot more inheritance disputes. Inheritance disputes sort of disappeared out of the law reports in the period between 1945 and 2000 or thereabouts. And since 2000, inheritance disputes, well, since the Thatcher years, inheritance disputes about small family businesses have come back. Okay. Are we going to expropriate or compulsorily collectivize all the small businesses? Well, I think people who've been forced into the position of actually pretending to be a small business when they're actually working fine but there's going to be an awful lot of people who do actually want to preserve their small businesses, and then doing forced collectivization on these people is just like the Soviets doing forced collectivization. It's going to be economically destructive and politically destructive. So it's inevitably the case that there's going to be a mixed economy. Assume we take power globally. I don't actually think it's practically feasible to take power on less than a European scale, because suppose we took power in Britain, the US would starve us out. The French and the Germans and the US would starve us out within 6 months. We aren't. It's a sort of the socialism in one country is a delusion which arises from the fact that it's socialism in the former Tsarist empire, which was a vast and self-sufficient, largely self-sufficient economy.
And that didn't work.
And even then didn't work. Yeah, at the end of the day, didn't work. But my point is simply that suppose that we take power on a large enough scale, there's still going to be a large number of people in small businesses, and we have to look forward to a mixed economy. And that means that we have to provide these guys, the people who are in business and so on and so forth, with the facilities to settle their disputes, which are about hedges. It's one of the things which gives rise to endless disputes in this country is height of hedges, or access to the business, for access to parking space for a business, or as I said, the inheritance disputes, the relationship breakups, and et cetera, et cetera, et cetera. So the immediate abolition of law is delusion. And indeed, we've again had the immediate abolition of law attempted. The Bolsheviks didn't attempt to abolish law, but the paradoxical effect of Stalinism was that they did abolish law because although there were loads of laws, well, at one level they abolished law in the Lenin era because they weren't prepared to legislate. They legislated everything through the Council of Sovnarkom. But in practice, actually, they didn't keep good enough records so that they would take a contradictory decision a week later. And everything wound up being, it gets referred to Comrade Lenin. Because the reason behind that is because the Supreme Soviet didn't meet regularly daily like Parliament, but only met periodically like the conference of a trade union. So that everything depended on Sovnarkom. There was no mechanism for legislation as distinct from what the Ottomans called a firman, an executive order in an individual case. So they weren't trying to abolish legislation. They didn't think they were abolishing law, but they did in fact abolish law. And then under Stalinism, because it didn't matter what the law was, because what mattered was whose friends you were. What bureaucratic patronage chain you were part of. The Chinese deliberately attempted to abolish law in the Mao period and all the way down to Deng Xiaoping, and then brought it back in and adopted a variant of one of the West European civil codes. The French revolutionists tried to abolish lawyers, but they crept back in. Basically, because people needed the facilities which lawyers could provide, and therefore but also because there were things they did fucked up so for example, the codifiers, a combination of Napoleon Bonaparte, who was a Corsican, together with the codifiers were a bunch of guys, academics who were specialists in Roman law. They reintroduced patria potestas, the right of life and death of the father over his children, and they copied English law community property controlled by the husband, so that radical subordination. They, in this case, actually, they adopted a position which was violently retrogressive because of ideological commitments. And then the lawyers brought in to try and find ways around that by making special contracts and arrangements and so on and so forth. So you try and abolish lawyers and you fail to do it. In the long run, law will be displaced by custom. But in the short run, no.
How do you distinguish between law and custom? What's your definition of custom?
Well, custom characteristically has the basis that this is, you can persuade the locals that this is the customary rule, and it rests on the agreement of the participants to its being custom. So it has this rather fluid character, and things can be custom and disappear. We have a whole load of the English Constitution is to a considerable extent composed of customs. And so it's a custom and not a law that the king doesn't veto acts of parliament. The right to veto acts of parliament is still there. And I wouldn't be surprised to see it actually coming back, given that the Tories have revived it in the context of the Scots Gender Recognition Bill, that the government, this is the government and not the UK Parliament vetoing the Scots Gender Recognition Bill, exercising the royal veto in reality. And in reality, actually, also Scotland, we have a whole load of land reform stuff, which the Queen and Prince Charles, before the succession, vetoed, but they didn't veto it to the point of letting it go through Parliament, and then you say at the end of the day, le roi s'avisera, because it has to be still in French. It still has to be in French. When they say the royal assent, they say le roi le veut, the king wills it. When they say no, they say le roi s'avisera, the king will think about it. But as Diana says, Queen Elizabeth did in fact veto, but what was done was to veto at the early stages when it's being discussed in government.
And secretly
And privately, as opposed to the old royal veto, which was exercised very, very, very publicly. However, so this is in terms of thinking about the future. I think there are things which we can think about, which we do need to think about for the future: codification of the law, defense and restoration of trial by jury, a load of stuff where, say, for example, the restoration of the freedom of action of local government, etc., etc., etc. It doesn't sound like law, but it is in fact law. It's constitutional structure, but not lawless. Not there is no law, because there is no law. Actually, the consequence of there is no law in a society which is not where we haven't overcome the social specialization of function, where we haven't overcome occupational specialization. The result is simply the return to cronyism and actually also inability to take decisions. This is the classic Boris Johnson's government was unable to take decisions, and the reason was because Boris was incapable of actually delegating authority and of taking decisions which would bind himself. In that way, you wind up with it becomes not merely unpleasant, but violently inefficient.
Hmm.
That's it.
Thank you for outlining that. We've got two comrades with their hands up, which I'm bringing in now. Comrades, if you want to ask a question or make a comment, please click raise hand. Or if you'd rather not, you can put your question in the Q&A and I can read it out. If anybody has put it in the chat, I won't be able to go through it all. So please put it in the Q&A. So Ian first. Where are you? There.
Hello.
Hi, comrade.
Good evening, colleagues. I just wanted to ask and make a few points about the centrality of the citizen. The ownership of oneself is at the heart of bourgeois jurisprudence, I would have thought. If you don't own yourself, how can you enter into the labour contract? You have to be able to sell yourself. Otherwise, the bourgeoisie can't extract a surplus from you in that way. And the other aspect about that, of course, is it has to be universal. In principle, it has to be universal. It should apply to all citizens. Otherwise, you're not a citizen at all. To be a citizen is to own yourself. You're not a serf, you're not a slave. And I just wanted to inquire as well about the aspect of reason in that, because as far as I'm aware, the earliest mental health law I can find is the Prerogativa Regis of the 14th century, which meant that if an earl was either insane or in the language of the time, a natural fool, the Lord Chancellor's Department could take over the estate so they didn't dissipate it. And the point, of course, was that law applies to property owners. In the 14th century, that would have been a noble person, a nobleman. But now, of course, it's everybody. And so we've had the Mental Health Act, the Mental Capacity Act, that kind of thing. So the ownership of oneself is central to being a citizen. And from that point of view, it's also one of the reasons why I think law is incredibly popular in one way. You can't be arbitrarily expropriated. You can't be arbitrarily locked up. And of course, this is very different to, if we can call it law in a feudal period, or a serf isn't a chattel slave. They aren't actual property, but they are tied to the land, and they don't have the same kind of rights. They have certain rights, but not in the kind of way that a citizen has. And of course, when we came to the Soviet Union, this was also a feature of it. You mentioned in your article about there not being the rule of law, and I would suggest that the reason why there wasn't the rule of law in the Soviet Union was because you didn't, strictly speaking, own yourself in the same way. It was illegal not to go to work, so it was a kind of semi-forced labor in a sense. But because the state couldn't really control people as they would like, it was transparent. That was the other aspect I wanted to get to. People in the Soviet Union knew that law wasn't law in a sense. They could see there was an arbitrary character to it. There were loads of laws, there was loads of legislation, there was lots of rules, but they were so dense and contradictory that unless you were a professional lawyer, you wouldn't know what they were. And so, in a sense, you were very vulnerable. By contrast, there is a rule of law for the most part in developed bourgeois societies, and it gives people a degree of comfort in a sense. And of course, some of us will be standing outside courts with placards reminding judges that juries have the right to reach a verdict according to their conscience. But and the other thing I wanted to ask was about the description of Yevgeny Pashikanis as a Stalinist. Of course, I mean, I took your point that politically he may well have been a Stalinist in the sense of supporting Stalin rather than the left or the right or whatever. But how would you say that Stalinism finds its way into Pashikanis's general theory of Marxism and law? That's me done.
Thank you, Ian. Mike, we've got two more people with their hands up. Would you rather hear a couple more people, or would you like to reply?
I'll just go quickly to that, and then, because I don't have an awful lot to say about it. Ian, on the question of self-ownership, it seems to me that it's again a question about the loose jointedness, because Arkwright spinning mills was staffed by orphans who he bought from the City of London under indentured labour, that they were legally obliged to go into Derbyshire and carry on working there for 8 years. Yeah. The presence of forced labour, the United States has very significant presence of forced labour in the prison service, and so on and so on. So that there's a overlaps of that. But I agree that the idea that you can't be arbitrarily locked up is not quite true, because well, how shall I do it? There's an offence called assaulting a police officer in the execution of his duty, but actually, in terms of people who've done observation of the magistrates' courts, usually what people get charged with this offence, it's actually for cheeking a police officer. Yeah. There's a sort of a lot of there's a widespread belief in, and there's enough routine practice to make people believe that law gives them security, but there's enough at the edges stuff that particularly for the working classes, it's less secure than it at first sight appears to be. USSR, on USSR, I agree with you that it's just transparent, that it's not there. Pashikanis is a Stalinist. I guess the clearest aspect of this is that Pashikanis' line on criminal law was that it's just social defense, Lombroso style social defense. Because the relationship of justice, of the equality, in his view, justice is grounded not on either self-ownership, as you put it, which I think is right, or on property rights, but is grounded on contract. And then he says contract is irrelevant, justice is irrelevant in relation to criminal matters. And therefore, criminal matters are concerned exclusively with the society defending itself against the criminals. And then it becomes, hey, it's just the criminals are outside the protection of the law. Okay, medievals thought the criminals are outside the protection of the law. As I said, Lombroso thought the criminals are outside the protection of the law, but the idea that criminals have rights is one which is present in early modern law and in modern law and so on and so forth. And Pashikanis' line on that, he says law is not relevant. And the same way, law is not relevant in public law. So the idea of constitutional rules is gone. That's it.
Thank you, Mike. Cheryl, please.
Yeah, just a couple of things. Apologies, I missed the beginning of your talk, but I'll have to rewatch it. I'm a lawyer myself. The questions I was going to ask of this, I mean, there isn't anything intrinsically wrong with the law, the concept of the law itself, is there? Isn't it just about the social relations, and that all the laws are to protect, you know, the capitalist class as things stand right now? I mean, it was my understanding that property law was introduced, for example, to create some kind of certainty in a capitalist society. My other questions are, sometimes I wonder whether or not working as a lawyer, can lawyers make any difference? You know, sometimes you wonder if you're kind of just banging your head against a wall in a sort of the way that the law mostly serves the ruling classes. What's your view on whether, you know, lawyers can make any difference in terms of challenging social relations and power structures as they are. And my last contribution is I heard the Just Oil activist Phoebe Plummer speak at a conference at the weekend. She was the young woman who threw tomato soup all over the Van Gogh painting. And it was just quite incredible, but not surprising, how many offences she's been charged with under, there's a whole thing at the moment about the protest laws changing, the criminalisation of protest, and the amount of convictions that she had been charged with, and also the amount of money that those oil companies are spending on their injunctions to prevent this, that, and to prevent people from protesting is just quite, talk about the fearsome nature of the state in terms of preventing protest. It's quite shocking, really. Anyway, that's all I was going to say.
Thank you, Cheryl. Mike, do you want to come back on that?
Yeah, very quickly. I think the problem with the concept of law is that law as distinct from custom. I said on the one hand, you can't have law without lawyers. But the flip side of it is that law as distinct from custom entails what makes it possible, because the reality is none of the words used in statutes are unambiguous. There's a lovely case which I occasionally use with students. I have occasionally used with students, recent Stevens Walbrook, which is about a parish church in London, which is a Wren church, and the vicar and one of the church wardens wanted to put a Henry Moore statue, which had a flat top in the middle of this cruciform church under the dome, 20-ton Henry Moore statue with a flat top. And the other guys objected. And the question is this 20-ton Henry Moore statue with a flat top a, quote, convenient communion table, which every church is required to have under the canons of the Church of England in 1603. And it was argued in the diocesan court and then in the Court for Ecclesiastical Causes Reserved whether this was a, quote, table. The diocesan court says it's not a table. Court for Ecclesiastical Causes Reserved says, no, the ordinary natural meaning of table is any elevated surface you can put things down on. So my point is simply that the words are ambiguous. What enables us to have a degree of certainty is the profession, and what enables there to be rule of law, as opposed to just having, you can have law and not have the rule of law. So ancient Rome has law, but it doesn't have the rule of law because the emperor, quod principi placuit agavit vigorem lex and princeps legibus salutus, the emperor, what the emperor wants has the force of law, and the emperor is not bound by the law. So FX already under Augustus, the poet Ovid is deported to Tomi, Constanza on the Black Sea for no reason. We don't know why. No, we still don't. We have no idea why Ovid was deported to Tomi. He's thought to have been caught up in the intrigue surrounding the emperor's daughter, Julia, but we don't know because Augustus could just say, fuck off, go away. So you can have law and not have the rule of law. To have the rule of law, you need to have financial support for lawyers to be independent of the state bureaucracy so that people can appear against the ministry, which practically means you can have rule of law for the benefit of the bourgeoisie, but we allowed ourselves to have it through legal aid. We allowed us to have it for the benefit of the middle classes and to some extent of the lower classes. and gradually that's being taken away in the recent past. Yeah, the Just Stop Oil stuff, I'm not going to say that that's novelty, because if we look at, Stephen Coleridge, the Protestant carpenter, in 1682, they charged him in London with treason. They couldn't get him in London. So when Parliament was summoned to Oxford, they charged him in Oxford with treason, and the evidence against him was the highest degree dodgy. But Francis North, who was Chief Justice of Common Pleas presiding over the trial, seized his papers from him on the basis that you weren't allowed to have counsel in capital crimes at that time, and therefore, if you weren't allowed to have counsel, you're not allowed to have been given any advice by anybody. Aaron Smith, who was the solicitor who had prepared the advice for him, was subsequently prosecuted for seditious libel for preparing the advice for Stephen Coleridge about how to cross-examine the witnesses against him. So that the government's and if one looks at when I was an undergraduate in 72, 73, we did civil liberties as part of the constitutional law course, and there was a whole load of cases about Communist Party agitators, or the skeleton army people who protested against the Salvation Army, and demonstrations and counter demonstrations in 1890s, 1930s, and moving on Communist Party speakers. There's lots of, in that sense, it's not new. But at the same time, what can lawyers do? It's certainly one of the things that lawyers can do, and I think lawyers can very usefully do, is actually explain to the general movement what the law is. How much can be done in court? I don't know. I mean, I'm an academic. It's certainly the case that there have been some things which people have done which have been brilliant stuff. But at the same time, there's also been stuff where people have, so Labour councils were given the most god-awful advice about in the 1980s and 1990s about devices to get, creative accountancy devices to get around rate capping. And they were screwed over because the lawyers who advised them were advising them on the basis that if you play the sort of technical games that ICI or Microsoft play, you'll get away with it, when the reality is that the courts were inevitably going to be biased against them. You had to assume that the courts would be biased against Labour councils. And it's giving people bad advice to advise them on the basis that there isn't judicial bias in cases which are political high-profile cases. So then some people may want to actually, and I guess this is true of the Just Stop Oil people, may want to run defences which result in them being martyred on the basis that it's more to the point for them to run the political defence which the court doesn't want them to run. And they're going to want a lawyer who will help them out with how to do that. And that we don't seem to have. It's clear that it's a problem with lawyers wanting to get a result. I can understand why people want to get a result for the client, even if it's getting a result for the client at the expense of the client's fundamental political convictions. But as I say, I'm not a practitioner, so I can't do that. That's it.
Thanks, Charles. I mean, the Save Our Juries campaign will be important in that respect, where they, trying to undermine the juries from, as you outlined, they're not allowed to speak to their reasons as to why, they did what they did. The Elbit Palestinian campaigners, as well as Just Stop Oil. That's a huge attack on the right of juries to here motivation, which of course is, you know, why you did something is crucially at the most crucial. So I would have thought there's a space to get involved in that campaign, which is in the process of being set up. Thank you.
Yeah, no, I was just going to come back to that point to say, yes, the other thing that was raised in the Just Stop Oil discussion was now they're preventing the defendants to give their reasons to the jury as to their motivation, because I presume they know that the juries may be sympathetic with the arguments they're putting forward. So the tactic now, I don't know if there's been a change in the law, but I assume so. They're not allowed to give their reasons as to, so that's all prohibited. Yeah.
The judiciary is not the least dangerous branch. We got Bushel's case and the right of juries to not be imprisoned for disagreeing with the judge, because the House of Commons had the Lord Chief Justice arrested and brought into Parliament for why he was to explain his unconstitutional activities. And then after that happened, the Chief Justice of Common Pleas conveniently backed off from the habit of imprisoning juries. We got Fox's Libel Act, which says that the judge has to allow the jury to give a general verdict as a result of a huge constitutional battle in 1760 to the 1790s. And it was Parliament, it was political struggle, not fighting over the legal doctrine, which achieved that. So it's the double-sidedness. There is a value in judges calling into question what the executive is doing, but at the same time, there is also a value in Parliament exercising serious supervision over what the judiciary are doing, and politics exercising serious supervision over what the judiciary are doing. And that's a present issue, but it would also be an issue in a future state that private judgments, private confidential disciplinary proceedings, all of this stuff is a problem. And yes, injunctions. Again, it's a reversal of stuff done in 1641, because the right to issue injunctions in tort was exclusively Star Chamber, and so the abolition of Star Chamber. Okay, the quote tidying up legislation abolished the criminal penalties which applied to judges who attempted to revive the Star Chamber jurisdiction, and since that was tidied away, the judges have been gradually reviving the Star Chamber jurisdiction.
Okay, last person with the hand up is Kevin.
Thanks, Mike. Very interesting talk, and I think some interesting points in the discussion. This is a question, and it's said from a position of considerable ignorance. So if it sounds naive or indeed unduly simple, please accept my apologies. I'm quite interested in the sort of sources of Soviet jurisprudence, and particularly the sort of application of the theoretical idea of sort of base and superstructure. And funnily enough, I came across a very outline article in an Irish journal recently on Pushikanus, and I was interested how far both Soviet jurisprudence, but maybe other writers, were influenced by, for example, the conceptions of the English common law, and particularly the idea of the jury, which is in a sense quite democratic. The other legal systems that I'm familiar with often have, inquisitorial judges, and obviously the Tsarist system had very limited limited democratic rights. But I'm thinking particularly of the influence, say, of the continental tradition, and I'm thinking of the way that, for example, German social democracy might have had an influence and again, a very different sort of, set of legal practices. I suppose it's the thing that interests me, and Ian Spencer sort of raised it, was really from sort of first principles about the nature of law and about the nature of the state and the nature of class society, but then the idea of social regulation and the relationship of that, of custom and of democracy. I am in favor, for example, of legal restrictions on rounds. It's one of my big bugbears, but it is a good example, I think, of an idea that we as socialists and the communists would like to see, in a sense, social regulation. We can all remember Lenin's point in State and Revolution, where he says that that in a civilized society, that if someone was being attacked, then passers-by would sort of intervene and help, and that sort of relies upon the idea of the collective, and again of collective custom. But I'm very interested in how, in a new regime, you're suddenly presented with, the ideas of regulating that regime, and bearing in mind that you're fighting a civil war, you've got counter-revolution armies of intervention, you've got massive economic problems, then the law is going to be very much influenced by that. But I suppose I'm then interested in how they were considering this and the sort of sources of that, and in particular the way that the very different legal systems that they both operated within, but also the different legal systems they could draw inspiration from. One of the reasons why I talk about the jury is that a few years ago, I was in a meeting in Germany, and I used the example, it's a very well-known one, of I think it was some religious people, Quakers, who carried out some minor destruction on an aircraft on the grounds that this, that this would, could be used to, perpetrate war crimes or, destruction. And my audience was generally surprised that a jury had the sort of power at that stage anyway to make a defense of conscience or lesser evil and damage and so forth. And indeed, the whole idea of the jury and that sort of democratic element, they were surprisingly ignorant about the role of that. And I wondered, given Marx's experience in Britain, and indeed other German socialists, Kautsky, Bernstein, and so on, how far that idea of the jury, had sort of penetrated their ideas. Anyway, but I'm sure that you could recommend some work on this to follow up on. But it is, I think, it's an interesting topic. And once we move beyond the idea that law is just, the sort of instrument of the ruling class, and that it will all be different under socialism, then I think we start to get to some quite interesting problems. Anyway, thanks, Mike.
Over to you, Mike.
Thanks. The idea that passers-by should intervene and help out is interestingly English and indeed West European medieval law. That the general position was you were expected to shout, "Stop thief! Help murderer!" etc., etc., and then people were obliged to come to your assistance. And under the Statute of Winchester of 1283, if you were subject to armed robbers in the highway in a parish and the parish didn't turn out to chase the armed robbers, you could sue the armed robbers for your losses. You could sue the parish for your losses. They had an interesting exception to this in relation to rape, that women were not expected to raise the hue and cry immediately on rape, but to make fresh complaints soon after the rape. So originally, the fresh complaint rule, which has been used in practice as a weapon against women, was originally a mitigation of a rule which applied to anybody who was victimized by any sort of criminal in the first place, was expected to actually raise the hue and cry. going along with that is the aspect, what lies behind the right to bear arms in the US Constitution was a duty to bear arms, to have arms suitable to your social position. And there's a case in the 1720s about a senior doctor who is being prosecuted for failing to keep a cavalry horse and sword and helmet. And he says, I'm a doctor. That's not, nah, you're still above certain amount of value, and therefore you're obliged to keep your weapons. Anyhow, that's the hue and cry. Pasha Khan has more awareness of English legal history than quite a lot of continental legal theoretical writers, but he doesn't seem to be particularly sympathetic to trial by jury. And it seems to me, I think this is actually probably also the case of with the Reform Acts and the expansion of the franchise also expanded eligibility to sit on the jury, which was previously restricted to the property classes. And when the Reform Acts came in and they expanded eligibility to sit on the jury, the capitalist, the legal profession, and I think the capitalist class lying behind them, become hostile to trial by jury. Previously, trial by jury had been not without tensions, but it had been basically accepted as a fundamental constitutional institution. But we get serious efforts to drive out, to weaken and trial by jury, and it gets abolished in accident cases, and then more recently in defamation cases, and it gets abolished in contract cases quite early on in the late 19th century. The consequence of abolishing trial by jury is an extraordinary level of public ignorance of the law, that if one reads drama or novels or journalism of the pre-1940 period, it's clear that the expectation of there's an expectation of a general knowledge of the law, which you would expect among Americans for the same reason that they have widespread trial by jury. But you don't expect in this country. I mean, there are assumptions made which second-year law students have difficulty following in newspaper articles, in pre-1940 newspaper articles. And back to this question of the jury. It's important to be clear about this. The rule is that the jury, the legal rule technically is the jury has a right to give a general verdict. And the judge cannot, in criminal cases, do anything if that verdict is, quote, perverse, unquote. Mm-hmm. So what the judges are doing is saying, well, nonetheless, we can say that the defendant can't say anything to the jury which will induce the jury to give a, quote, perverse general verdict. I think that's, as I say, I think it's a violation of Article 6 of the Convention on Human Rights, because it's not a fair trial under circumstances where you're not allowed to, where the judge controls what the defendant says to the jury. And it's a violation of it's a violation of Magna Carta. There's also a general violation of Magna Carta going on, which is the Cheryl referred to the amount of money being spent on injunctions. Magna Carta Cap 29 says, to no one will we sell, to no one deny justice. So the fact that there's no maximum expenditure on lawyers, which there was until the reign of Queen Victoria, amounts to the Queen or the King, as the case may be, franchising to the legal profession the sale and denial of justice in violation of Chapter 29 of Magna Carta. which I guess would be an argument for saying, and therefore the legal title to the crown is divested out of the House of Saxe-Coburg-Gotha and vests in the Hanoverian successor. There is actually a Hanoverian successor, a person who is the next heir to George the Fourth, if we disregarded the current royal line. But that's a sort of, hey, we're not interested. We want a republic, not a nicer monarchy. But yeah, fighting for trial by jury. Why the Bolsheviks? It's interesting because they call it people's courts, but it's not in fact committees of the Soviets. The people's courts under the Bolshevik regime from early 1918 is a judge sitting with two assessors. So that it's much more, yes, it's much more like the German system. And I guess it's the German system which influences them in that respect. Other than that, the general point, Felicity made the issue that the majority can make bad laws. It's true, the majority can make bad laws. And having the constitutional checks and balances doesn't stop them. Witness the drug laws in the United States. Elaborate constitutional protections, but the majority has passed a series of laws which have been promoted essentially by a combination of vice squads who were out of work because of the abolition of protection of the prohibition of alcohol, together with journos on the crime beats, have created this enormous moral panic about drugs and the practical consequences of this. Okay, so then I end the critique article, which I know people won't have read, but I end it with the point that it's a statement made by one of the American revolutionaries that the price of liberty is eternal vigilance. And socialists can make choices which promote eternal vigilance, trial by jury, local government, conscript army, conscript police force, and stuff like that. But we can't expect that the judicial system or the lawyers or anything like that can substitute for the need to pay attention to what the fuck these guys are doing. And I think it's all more generally, we need political party with its own press, which also can ventilate why the advertising funded press are lying to us. And if we had something rather better than the Morning Star, we could have somebody doing a column of the latest scandalous stuff which is being done in the courts, or even actually Private Eye used to do a column called Justinian for the Money. Justinian for the Money. Justinian was Roman emperor who did a load of law stuff. That exposure activity, it seems to me, is fundamentally important in this context. That's it.
Fantastic. Thank you very much, Mike, for joining us tonight. I think it was a really wide-ranging discussion touching on all sorts of, origins of the law and to a future society, and the replacement of laws with custom through time, I think is quite important. So thank you very much, Mike, for outlining what Marx said and didn't say, and what we perhaps have to work on when we're developing a socialist program for the future.
Well, thank you for the invitation.
Very welcome. Next week, we'll be looking at Marx and war, or Marx and Engels and war with Ian Spencer, and then the week after, Marx and nature. And then we're going to take a break in August, and we'll come back at the end of August with another really important sub-series, which is Marx and party building, which really touches on what we have to do today as well. Thank you very much, Mike. Thank you very much, comrades in the audience, for contributing and making it such an interesting session. Good night. See you next week.